Hi, it's Mike DelSignore, and in today's video, I want to talk about what it means to have your Miranda rights violated and explain to everybody what Miranda rights are and what they're not. Because it's a very common question. Somebody will call me about an OUI or a criminal charge, and one of the things I'll say is, the police didn't read me my Miranda rights. And that can be important, and it might not be. Hopefully it's not important, because when it's important, it means that you said something incriminating, you said something bad for the case that we need to get excluded from evidence. So if you're asserting your innocence, if you don't say anything that incriminates you, or if you say nothing at all, then if the police don't read your Miranda rights, there's no remedy there. There's essentially no harm, no foul, basically. You don't get anything in the criminal law for just them violating some rights or doing something wrong. There has to be a consequence with Miranda. Now, the Fourth Amendment, if they don't have reasonable suspicion of probable cause to arrest, then the case gets thrown out. Miranda, you have to, if you make an incriminating statement and they don't read your Miranda rights, it can get tossed out of court. But now let's talk about what it is. When do they have to, police have to read Miranda rights, number one, and what rights do they have to read? And two, what type of questioning or interrogation counts as interrogation that could result in statements being suppressed. So for Miranda to apply, you need two things. You need custody and interrogation. So let's talk about custody. That's a lot of times where Miranda rights don't apply. For example, when you're pulled over by the police and they start questioning you, they ask you, where are you coming from? How much do you have to drink? Can I have your license and registration? And even when they ask you to get out of the car and do some field sobriety tests, the law has said that that's not custody yet. So police don't have to read you Miranda rights. It can be custody in certain circumstances, but generally speaking, it's a roadside encounter and it's non-custodial. That came from a case decided by the U.S. Supreme Court in 1984, Berkshire versus McCarthy, which held that an OUI, because it's a routine roadside questioning open to the public, it's not the type of custodial setting that was contemplated by Miranda. So Miranda came about it was decided in the 1960s, and it came about because as a way to enforce the Fifth Amendment. So under the Fifth Amendment, we have a privilege against self-incrimination. And back in the 60s, police would sort of compel confessions. They would have people at police stations, and they would do different interrogation tactics that would be designed to lead to a confession. And so Miranda was a rule designed to prevent basically police coercion that would result in these confessions. And basically, false confessions is a leading source of wrongful convictions in the United States. So the United States Supreme Court, in the Miranda decision, is a decision by Chief Justice Earl Warren. He was one of our best Supreme Court justices. He was appointed by a Republican judge, actually. He was appointed by President Eisenhower. And Eisenhower appointed two of our most liberal justices to the United States Supreme Court. He appointed Chief Justice Warren, who formerly was governor of California, and Justice William Brennan. So it goes to show you that sometimes you can't predict how a judge will act on the court based on political party affiliation. So, but anyway, the Miranda warning requires this warning. It requires the police advise you have a right to remain silent, that anything you say can and will be used against you in a court of law. You have a right to an attorney present and during questioning, and you have a right to an attorney. And this issue of how far does the warnings go, I'm going to discuss some of that because there's some case law about how specific these warnings have to be. You have a right to a lawyer if you can't afford a lawyer, and you have a right to stop questioning if you start answering questions and request a lawyer. So those are your basic rights, and the issue of whether the warning requires more than just the right to a lawyer, but the right to a lawyer present during questioning is an issue in front of the U.S. Supreme Court. It's on a petition for certiorari, so maybe the U.S. Supreme Court doesn't deem it worthy to be decided, but it's the case of Michigan versus Matthews, where the U.S. Supreme Court is going to decide whether the right to an attorney warning is sufficient, or whether the warning also should be that you have a right to an attorney present during questioning. So one of the things, let's say you made an incriminating statement and the first thing we want to do is see if you're in custody. So custody is defined by the court as when your liberty is detained, when your liberty, your freedom is limited in a manner equivalent to that of a formal arrest. So certainly when you're arrested, you're in custody, police have to read Miranda, but it can happen prior to that. So where is that line? So when you initially pulled over, the police don't have to read you Miranda, but after the field sobriety test, at this point, I think there's a good argument that police have to read you Miranda even before they say you're formally arrested. At this point, they're focusing on you. It's not just an investigation. You've already done some field exercises. So a lawyer can argue that you're in custody prior to formal arrest, and that's an issue for a judge and for courts. We have a case, Commonwealth versus Bryant, that sets forth essentially the factors that our court looks for in determining custody. So once you have custody, then the next thing you need is an interrogation. So if you're in custody and you blurt out things like, "I'm sorry, it's my fault, go easy on me," or any statement that's not in response to law enforcement interrogation, then it would likely come into evidence. So it has to be a police questioning that prompts the response. So you need interrogation, custody, and then when they read you the warnings, then the issue is, are the warnings good enough? Generally speaking, if they read the warnings that I just read, well, that'll probably be good enough. Those warnings go beyond what the U.S. Supreme Court originally required. So you want to make sure, one, the warnings were read, two, that there was proof that there was custody, and three, that there was interrogation. So if you prove these things and someone's made an incriminating statement, the statement may get suppressed from evidence. So that's what Miranda in a nutshell. So if you have somebody on the side of the road, the issue of when the person's in custody is going to be something you'll have to litigate. So when do when does this issue get litigated? It would be at what they call a motion to suppress hearing. And in a motion to suppress hearing, the officer would come in, and it's like a mini trial on the legal issue of the case. So the judge would hear testimony to determine these issues. When you were in custody, were you interrogated? Was the warning given? So that's a motion to suppress hearing. I do many motions to suppress. Often I'll combine a motion to suppress on Miranda with motions to suppress the stop, the exit order, and other things to get as many legal issues before the court as possible, because it gives us more testimony, more information. Even if the motion is denied, it can be useful in preparing the case for defense. So if you have questions about Miranda is a legal issue. These cases get decided every day. Courts across the United States define what warning and what degree of protection the court should provide to make sure the Fifth Amendment is upheld and enforced in court. So my name is Michael DelSignore. My passion is to help people charged with criminal charges get their life back together. I've been doing this my entire career, been focused on criminal defense. You can find my writings online. Follow me on Facebook. On my YouTube channel, I frequently post on issues related to criminal defense. You can call, text, if you're charged with a criminal offense, or if you just have questions, 781-686-5924. It's never too early, too late to call. I'm here to help you and here to answer your questions on any area of criminal law, but especially Miranda rights.